Sign this. 2 words. And the moment you take that pen without knowing what signing actually means, what it does not mean, what rights you are not waiving, and what rights you absolutely need to assert before that pen touches paper, you have closed the one window in a traffic stop where you had control over what goes into the record. Most drivers sign immediately because they want the encounter to end. A few refuse because they believe signing is an admission of guilt. Both groups are operating on assumptions that are wrong. Signing a traffic citation is not an admission of guilt. But what you say and do not say in the 30 seconds before you sign determines whether the stop ends with a piece of paper, or whether it continues into a search, a questioning sequence, and an investigation that the citation was never supposed to produce. The signature moment is the last leverage point of a traffic stop. It is the moment the officer wants the encounter finalized. And it is the moment you have the most to protect and the clearest opportunity to put the right things on the record before the encounter closes. Subscribe to this channel right now, because the video after this one covers what happens when signing the ticket is followed by a search request the officer waited until the end of the stop to make, and that timing is deliberate. It has its own legal architecture and its own exact words that this channel covers in depth. Before the words, you need to understand what signing a traffic citation actually means, because the assumption most drivers carry into that moment is wrong in both directions, and the wrong assumption in either direction produces a response that damages them. The first wrong assumption is that signing is an admission of guilt. It is not. In virtually every jurisdiction in the United States, a traffic citation signature is a promise to appear, either in court to contest the citation or at a payment portal to resolve it. The signature is a procedural acknowledgement, not a plea. It is not a confession. It is not a waiver of your right to contest the underlying violation. It is not a concession that the officer's account of the stop is accurate. A driver who refuses to sign on the grounds that signing is an admission has misunderstood the document and, in many jurisdictions, has just converted a civil traffic matter into a custodial arrest, because refusal to sign a citation is an arrestable offense in most states. The officer is not offering you a choice between signing and going free. He is offering you a choice between signing and being taken into custody. The second wrong assumption is that once the citation is issued, the encounter is effectively over and nothing you say in the next 30 seconds matters. This is the assumption that produces the most preventable damage. The post-citation window, the 30 seconds to 3 minutes between citation issuance and the driver pulling away, is frequently the window in which officers make consent requests, ask follow-up questions, and transition a concluded citation stop into a new investigation. And drivers who believe the encounter is over drop their guard precisely when they need to maintain it most. Here is the piece of information that most drivers are never told, and it is the one that changes the entire character of the signature moment. Signing a traffic citation does not waive any of your constitutional rights. It does not waive your Fourth Amendment right to be free from unreasonable searches and seizures. It does not waive your Fifth Amendment right to remain silent. It does not waive your right to contest the factual basis of the stop in court. It does not constitute a consent to search the vehicle. It does not constitute an acknowledgement that the officer's observations were accurate. It does not prevent you from challenging the constitutionality of the stop in a subsequent legal proceeding. And yet, the moment most drivers sign the citation, they behave as though the encounter has been finalized on the officer's terms, answering the officer's follow-up questions, responding to casual conversation that is still being recorded, staying in their vehicle while the officer lingers, and in some cases agreeing to a search request that arrives in the same breath as "have a nice evening." The signature finalizes nothing except your promise to appear. Every right you had at the beginning of that traffic stop, you still have at the moment the pen is handed to you. The signature does not close the constitutional ledger. It closes the citation. Those are not the same document. Here is the investigative sequence that makes the signature moment so consequential, and it is the one that is deliberately timed to arrive when the driver is most psychologically vulnerable. Research on compliance psychology has documented that people are most likely to agree to a significant request immediately after completing a smaller, routine action. The completion of the small action, signing the citation, creates a psychological register of task completion that makes the person feel the encounter is resolved, and that residual cooperation is a reasonable extension of the goodwill the resolution produced. Law enforcement training programs are aware of this psychology. The request to search a vehicle, in many documented cases, is deliberately positioned after the citation has been issued and signed. After the officer has said something like, "Okay, you are all set," or "Here is your copy," precisely because the driver's compliance threshold is at its lowest at that moment. The driver who just signed the citation, who just received their copy, who just heard "you are all set," is a driver who believes the threatening part is over. That driver says yes to "Can I take a quick look?" before they have fully processed that the encounter was not actually over. The post-citation search request is not a coincidence of timing. It is a trained technique. And the signature is the trigger for it, not because signing produces consent, but because signing produces the psychological state that makes consent most likely. Understanding the timing is what allows you to maintain the same response discipline in the post-citation window that you maintained at every earlier stage of the stop. Here is the specific trap that catches drivers who have learned that they do not have to consent to things, and who apply that principle incorrectly to the one thing at a traffic stop that actually is required. In most states, a driver who refuses to sign a traffic citation can be placed under arrest immediately. The signature is not optional in the sense that field sobriety tests are optional. Field sobriety tests are voluntary evaluations. A citation signature is a statutory requirement, the mechanism by which the driver acknowledges receipt of the citation and promises to appear or pay. Refusing to sign converts a civil traffic enforcement action into a custodial arrest that produces an arrest record, a booking process, a vehicle impoundment, and an inventory search of the vehicle, all from a refusal that the driver believed was an assertion of rights. The arrest is not the officer being punitive. It is the legal consequence of refusing to comply with a statutory requirement that exists in virtually every state's traffic code. A driver who knows this will sign the citation without hesitation, not because they agree with it, not because they cannot contest it, but because refusing to sign produces consequences that are categorically worse than the citation itself. Sign the citation. Contest it in court. Those are the two correct sequential decisions. The signature is not the contest. The court is the contest. Here is what the 30 seconds before you sign should look like, because this window is not dead time, and it is not the moment to drop your guard. There are 5 things that belong in that window, and knowing all 5 before you are in the encounter is what allows you to move through them without hesitation. The first is to read the citation. Not skim. Read. The citation documents the stated basis for the stop, the violation alleged, the officer's identifying information, and in some cases factual details about the encounter that will be relevant if you contest the citation or if the stop escalates. A citation that documents a factually inaccurate account of the stop is a document you want to have read before you signed it, so that any contest you file has the benefit of your contemporaneous memory of the discrepancy. The second is to confirm what you are signing. Ask the officer directly. Is this a promise to appear and not an admission of guilt? In most jurisdictions, the answer is yes, and getting that confirmation on camera protects you from any subsequent characterization of the signature as an acknowledgement. The third is to state your non-consent on camera before you sign. The sentence, "I want to note for the record that I do not consent to any search of this vehicle or my person," said clearly, before the pen touches paper, creates a documented non-consent that survives the signature and protects you from any subsequent claim that post-signature cooperation implied consent. The fourth is to invoke your right to remain silent on any follow-up questions before they are asked. I am invoking my right to remain silent on any further questions before the officer asks them. On camera. On record. The fifth is to ask immediately after signing. Am I free to go? Get the release on camera. Start your departure before the follow-up request arrives. Here is the legal foundation, and it contains the framework that makes every piece of what you do before signing constitutionally significant. The Fourth Amendment protects you from unreasonable searches and seizures throughout the traffic stop, including the post-citation window. Rodriguez versus United States, decided by the Supreme Court in 2015, held that a traffic stop cannot be extended beyond the time reasonably necessary to complete the stop's mission without independent reasonable suspicion of criminal activity. The mission of a citation stop is complete when the citation is issued and signed. Any extension beyond that point, any follow-up questioning, any lingering, any request to search, requires independent reasonable suspicion that exists apart from the completed citation. A consent request made after the citation has been signed, in the post-citation window, is either within the legitimate duration of the stop or it is an extension that Rodriguez renders constitutionally suspect, depending on whether independent reasonable suspicion has been developed. Your immediate departure after signing, combined with your stated non-consent before signing, closes both avenues. The Fifth Amendment protects you from answering investigative questions in the post-citation window, just as it did throughout the stop. The signature did not waive it. The completion of the citation did not suspend it. Your Fifth Amendment right travels with you through every stage of the encounter, including the final 30 seconds. Illinois versus Cabal addressed the permissible scope of activity during a traffic stop and the degree to which ancillary investigations require independent justification. Schneckloth versus Bustamante addressed the voluntary nature of consent and what the government must show to establish that a consent was knowing and voluntary. A driver who has stated non-consent on camera before signing has made the Schneckloth analysis straightforward. There is no ambiguity about whether the subsequent search was consensual. So here are the exact words, in the precise sequence they belong in the signature window. When the officer hands you the citation and says, "Sign this," you do not sign immediately. You read it first. Then you ask, "Officer, just to confirm, this is a promise to appear and not an admission of guilt, correct?" Wait for the confirmation. It will come. Then, before signing, you say, "I want to state for the record that I do not consent to any search of this vehicle or my person, and I am invoking my right to remain silent on any further questions." Then sign. Then immediately, "Am I free to go?" Every component of that sequence is doing specific legal work. Just to confirm, this is a promise to appear and not an admission of guilt. This question is not a delay tactic. It is a clarification that goes on camera, protects you from mischaracterization of the signature, and signals legal awareness at the moment the officer is hoping for unreflective compliance. In the vanishingly rare case where the officer gives an answer that suggests the signature is something other than a promise to appear, you now have a documented basis for contesting what you were told before you signed. "I want to state for the record that I do not consent to any search of this vehicle or my person." This sentence is the most important thing you can say in the signature window. It closes the consent avenue before the post-citation request arrives. It creates a documented non-consent that survives the signature. It removes the psychological compliance dynamic that the post-citation window is designed to exploit, because a driver who has just stated non-consent on camera cannot easily reverse that position 30 seconds later without the reversal being equally documented. "I am invoking my right to remain silent on any further questions." This sentence closes the post-citation questioning avenue simultaneously. Any question asked after this invocation is a question asked of a driver who has invoked silence. The questions, and the officer's decision to continue asking them, are on camera. "Am I free to go?" This initiates your departure before the follow-up request has a chance to land. The answer should be yes. If it is not, you have just been detained in the post-citation window without the independent reasonable suspicion Rodriguez requires, and that detention, and everything it produces, is constitutionally suspect. The pushback at a citation signing stop is different from the pushback at any earlier stage of the encounter, because the officer has completed the formal purpose of the stop, and any continuation requires a new justification that he has to produce on the spot. Know every version before it arrives. If the officer says, "Do you have any questions about the citation before you sign?" this is a common opener that extends the window. You do not have questions about the citation that require answers at the roadside. Those questions belong in court. No thank you, officer. Then proceed with your pre-signing statements and sign. If the officer says, "Before you go, do you mind if I ask you a couple of questions?" this is the post-citation conversation opener. "Officer, I am invoking my right to remain silent, and I do not consent to any searches. Am I free to go?" If the officer says, "Do you mind if I take a quick look in the vehicle before you head out?" this is the post-citation consent request. "Officer, I do not consent to any search of this vehicle." Clear. On camera. Then, "Am I free to go?" If the officer says, "You seem nervous. Is there anything in the vehicle I should know about?" a post-citation observation fishing for a voluntary disclosure. Your response does not change. If the officer does not immediately respond to your "Am I free to go?" question and lingers at the window, "Officer, I want to clarify. Am I free to go, or am I being detained?" Make the declaration happen. Do not let the ambiguity of lingering produce a compliance response. If the answer is that you are being detained, "Officer, on what independent basis are you detaining me after the purpose of this stop has been completed?" Rodriguez on camera. If handcuffs come out for any reason, I want an attorney. For words, everything stops. Here is the technique that the post-citation window is most commonly used to deploy, and it is the one that catches drivers who were disciplined throughout the stop but relaxed at the wrong moment. The final approach is the technique of conducting the most significant investigative step of the entire encounter at the moment the driver believes the encounter is over. It relies on a simple psychological mechanism. Throughout the stop, the driver was guarded. They were aware that the encounter was active, and they maintained some level of caution. The moment the officer says, "Here is your copy of the citation," the driver's nervous system registers resolution. The threat has been processed. The outcome has been determined. The remaining interaction feels like a social wind-down rather than a continuing investigation. And in that window, in the 15 to 45 seconds between the officer handing back documents and the driver pulling away, the question that arrives feels like casual conversation rather than what it actually is. The final approach works because it arrives when the driver's guard is lowest and their compliance threshold is highest. The drivers who protect themselves through it are not the ones who were suspicious of the officer's friendliness. They are the ones who maintain the same response discipline in the post-citation window that they maintained at every earlier stage, because they understood that the encounter is not over until the vehicle is moving, and that the signature is not the end of the stop. It is the beginning of the most psychologically targeted 30 seconds of it. Here is something that should happen after every citation you receive where the factual basis or the constitutionality of the stop is in question, and it is the part of the traffic citation process that most drivers never use because they do not know it exists or because they believe it is not worth the effort. Every traffic citation that reaches your hand is a document you have the right to contest, not just speeding tickets with disputed speeds. Every citation, the constitutionality of the stop itself, can be raised in a traffic court proceeding. If the stop lacked the reasonable, articulable suspicion the Fourth Amendment requires, if the tip that generated it was constitutionally insufficient, if the stated violation did not occur, if the stop was pretextual, those arguments belong in court, and they are raised by contesting the citation rather than paying it. The body cam footage from the stop, the officer's notes and report, the dispatch records that show what information generated the stop, all of that is discoverable in a contested citation proceeding. A driver who signed the citation, drove away, and paid online has closed that window permanently. A driver who contested has opened a discovery process that surfaces everything the officer documented and everything the department's systems recorded about how and why the stop was initiated. Even if the contest does not succeed on the violation itself, the discovery process can produce information that is relevant to any related criminal proceeding that emerged from the same stop. The citation is not just a fine. It is a document that begins a legal process, and that process has options that payment forecloses. The body cam captures the signature window in full, and it is one of the most watched stretches of footage in any case that involves a post-citation search, consent challenge, or extended detention claim. Judges reviewing suppression motions look specifically at the post-citation window to assess whether the extension of the stop was justified, whether the consent was voluntary and informed, and whether the driver's behavior before or after signing produced the independent reasonable suspicion that the extended detention requires. A driver who stated non-consent before signing, invoked silence on further questions, and immediately asked to leave. That driver on that footage left the officer with nothing to work with in the post-citation window. The extension, if it happened anyway, is a Rodriguez violation with a documentary record. The consent request, if it came anyway, was met with a documented refusal. The questioning, if it continued anyway, was directed at a driver who had invoked silence on camera. Every subsequent action the officer took in that window is an action taken against a documented assertion of rights. That is the strongest suppression foundation available. A driver who relaxed, chatted, answered the follow-up questions, and agreed to the quick look That driver handed the officer every post-citation tool in the playbook in the 30 seconds after they believed the encounter was over. The signature was not the end. The signature was the beginning of the window the officer was waiting for. Make sure the body cam shows a driver who knew that. Memorize these before you close this video. When the officer hands you a citation and says, "Sign this," read it. Then ask, "Officer, just to confirm, this is a promise to appear and not an admission of guilt, correct?" Then, before signing, "I want to state for the record that I do not consent to any search of this vehicle or my person, and I am invoking my right to remain silent on any further questions." Then sign. Then immediately, "Am I free to go?" If post-citation questioning begins, "Officer, I have invoked my right to remain silent. Am I free to go?" If a search request arrives, "Officer, I do not consent to any search of this vehicle. Am I free to go?" If the departure is blocked without justification, "Officer, on what independent basis are you detaining me after the purpose of this stop has been completed?" If handcuffs come out, "I want an attorney." 5 positions, all grounded in Rodriguez versus United States, Schneckloth versus Bustamante, the Fourth Amendment, the Fifth Amendment, and the documented reality of how the post-citation window is used to produce the consent and the statements the stop could not produce before the citation was issued. None of them require refusing to sign. All of them require knowing that the signature is not the end and that the 30 seconds after it are the 30 seconds the officer has been waiting for. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances. If this video reached you before an officer ever handed you that pen, it did exactly what it was built to do. Subscribe to this channel right now, because the citation signature is one moment in a traffic stop that connects to searches, to extended detentions, to post-stop investigations, and to courtrooms. And every one of those connections has a legal framework and a set of exact words that this channel covers one by one. One scenario, one constitutional foundation, one set of words, so that when that pen arrives, you are not signing with relief that the encounter is almost over. You are signing with the understanding that the next 30 seconds are the most psychologically targeted of the entire stop, and with everything on the record that needs to be on the record before the window closes. Subscribe. Share this with every driver you know. Someone watching tonight is going to sign a citation tomorrow and hear those follow-up words in the same breath and have no idea that the stop was not actually over. Make sure they know. Make sure they know what to say before the pen touches paper. Make sure they go home protected. Stay calm. Stay protected. Stay free.